Hello and welcome back to another installment of the Vitale Law Firm Estate Planning Educational Video Series. My name is Allison Schultz. I am a paralegal here, and today I'm going to be explaining a little bit about what an estate plan is and getting through some basic concepts. So what is estate planning? An estate plan is a comprehensive plan that addresses how you and all of your stuff, all of your assets are to be managed, whether that be when you're incapacitated or after you pass away. Estate planning protects your legacy by directing the right property to the right people at the right time. So this slide contains some of our most frequently asked questions that we get from clients at Vitale Law Firm, starting with, why do I need an estate plan? The simple answer is estate plans can look a variety of different ways, and until you meet with a competent estate planning attorney, you won't know which plan is best suited for your situation and will allow you the most control over your assets. The next question is, what if I die without an estate plan? Which happens all the time. The state, so in Missouri, if you were to die in Missouri, Missouri would decide what happens to you and your stuff. If you had no kind of estate plan whatsoever, your estate would go through the probate court system in Missouri, and that would be entirely facilitated by that court, and you really would not be able to express very much control over that at all. The probate court decides who will end up with your assets and who will receive your money and property once you pass away. Some downsides of probate is that it's extremely time consuming. It can take anywhere from 6 to 18 months, depending on the complications that arise, and they do arise through the probate process. Probate is expensive. Along that process, the court fees, lawyer fees, and other administrative costs can really add up, and this can significantly decrease the size of your estate. Additionally, the probate process is completely public and can leave you exposed to potential creditors and puts all of your information out there for anyone to access. How do we then avoid probate? To avoid probate, you have to die with no accounts or property held in just your name. And if it is in just your name, making sure you have updated and accurate beneficiary designations on that asset. Here's a list of documents that we always suggest our clients to have in any comprehensive and well-rounded estate plan, starting with the last will and testament. Chances are you've probably heard of a will and what a will does, and this streamlines the probate process. We also include power of attorney documents, so for financial and healthcare matters, if you were ever to become incapacitated, this would give your named agent access and control over finances and healthcare decisions. Additionally, we include what is called an advanced healthcare directive or a Missouri living will. If you are in a permanent vegetative state and relieves the burden of making end-of-life decisions from your named healthcare agent. You explicitly state your wishes to the healthcare community through this document and makes the entire process easier. Number 5, we have guardianship documents listed. This is if you have minor children and you want to make sure that if anything were to ever happen to you, that they would be protected and cared for. And number 6, a revocable living trust. We will get into a little bit more about what a revocable living trust is. And plainly, it is a trust that is going to avoid probate completely. So let's talk a little bit about wills. So if you have a will, you have some significant control over the distribution of your assets, as well as who will be administrating that will, aka your executor. You can also plan for guardianship for minor children and save a little bit on the cost of probate as a whole, as a will would streamline that process, barring any contests or complications that would arise through the probate process. So in Missouri, if you were to die without a will, you would go through the probate process and your assets would be distributed according to Missouri's intestate plan. In a few words, the Missouri intestate plan is going to find your nearest living relatives. So basically the court assesses and decides beneficiaries on your behalf. Additionally, the probate court will also choose an executor of your estate if you do not have a will. Alrighty, let's talk a little bit about power of attorneys. So what is a power of attorney for financial matters? A power of attorney is a legal document in which you would name an agent to act on your behalf in all matters concerning finances. They could open a bank account for you, they can sign checks for you, they can file your taxes, cancel your Netflix accounts. So several different types of power of attorney. What they can be immediately effective. They can be effective only upon incapacity as determined by the medical community. And then they can also be limited significantly in their powers. So what is a healthcare power of attorney? Kind of like the financial power of attorney in the way that you would name an agent to make healthcare decisions on your behalf. We always stress here at Vitale Law Firm that you should choose this person wisely. Can the person that you name as your agent handle the responsibility and the burden of making such difficult decisions? And can they remain level-headed and calm in an emergency situation? An advance directive is a legal document that allows you to provide specific directions about your end-of-life care and end-of-life preferences, so your loved ones are not left guessing shall that time come. This relieves your healthcare power of attorney of making those really hard decisions, especially in such a volatile time if they are a family member, a loved one. And just to clarify, an advance directive is not a DNR or a do not resuscitate order. So let's talk a little bit about trusts. Before we begin, I just want to go over some important terms. So a grantor is somebody who authors the trust. This is who would meet with an estate planning attorney to gauge the situation that they have and write a trust that best fits their needs. They are also going to be acting as that initial trustee, which basically means that the trust is set up to benefit that grantor during their lifetime. And then after they pass away, successor trustees would step up to administer that trust according to the grantor's wishes. Let's talk about what a beneficiary is. A beneficiary is somebody named by the grantor that is going to receive those assets after that grantor passes away. Think of a trust like a private contract that you as a grantor would make between yourself, your trustee, and your beneficiaries. It provides you, the grantor, with complete control over how and when assets will be distributed to those beneficiaries. So the most common type of trust that we see is a probate avoidance trust. Like I mentioned earlier on, probate is not something we want to make our families or ourselves go through at any time. And so a revocable living trust is a way to avoid that whole process. There are also some things called special needs trusts, Medicaid asset protection trusts, also known as irrevocable trusts, and charitable remainder trusts. So here's a very pared down diagram of how a trust works. So if this bubble represents your family trust, you would move the interest of your assets. So you would change the POD beneficiary on your bank account to be the trust. You would transfer the ownership of your home or any other real estate that you have into the trust. So it would be owned by the trust. And that's what we call funding. Of course, there are exceptions to this. Some assets, the trust will be named as either secondary or tertiary beneficiary, and those are tax qualified accounts and things like that. And like I said over here, you are the trustee for the remainder of your life. You set up the trust to benefit you primarily, and then that successor trustee acts as sort of an administrator of that trust after you die. Beneficiaries, you are a beneficiary of the trust for as long as you live. Like I said, it exists to benefit you. And then after you pass away, would be named loved ones or charity. So let's talk about some big differences between a will and a trust. A will is only effective upon the death of the person who created that will and is dependent upon court approval. A will requires a probate proceeding. It is a public document that can expose you to creditors because it is public. And the administration of a will is really uncertain. Like I said, it's kind of up in the air until a probate court recognizes a will's validity. A trust, on the other hand, is effective upon execution and continues beyond the death of the trustor or the person making that trust. So, say, for example, you have a minor child, those assets can be held in trust until that child reaches a certain age that you designate. Trust is inherently private. The only time a trust would have to go through the court process at all is if somebody, an interested party in that trust, challenges the trust language or the trustee itself. And ultimately, a trust allows you to garner more control over how your assets will be distributed and to whom. So, in estate planning, there are also some special considerations that we can mold and design an estate plan to specifically cater to. So, for example, if you have minor children, you can appoint temporary and permanent guardians for those children. You can also choose who will manage the money for that minor child until they reach a certain age and can receive a distribution. So, without a trust or an estate plan in place, a judge will decide who will be the guardian of those minor children, and money would be distributed outright to that child upon them reaching adulthood, which they might not be ready for. Some beneficiaries need a little bit extra help. Say they're not so good at managing their own money, they have creditors trying to collect from them, they are in a high risk job that could potentially lead to lawsuits. There is also concern potentially over divorce and things like that. So, what a trust would do is it would protect that beneficiary. And instead of gifting all of that inheritance to them outright, you can specifically stipulate certain conditions that need to be met before any distributions would take place. Another thing that we see a lot here at Vitale Law Firm is blended families. So in a lot of times in these situations, you have separate property, you have individual children, and you have some outstanding obligations, say for example, prenuptial agreements, settlements, things like that. And we can specifically design a plan to protect you and your blended family. So we can also include some special needs planning within your estate plan. Say you have a special needs child or loved one that needs some special considerations. We can work that into an estate plan. We can cater an estate plan so that they still receive government benefits, their inheritance could be protected and structured the right way. Create something called a special needs trust. And if you have any questions about a special needs trust, you can always call our office and we'd be happy to explore that further with you. And business owners. So earlier I mentioned that Vitale Law Firm is not only an estate planning law firm, but it also a business law firm. We always tell our business owners to make sure that they have some sort of business succession plan in place. So in estate planning, we treat a business no different than any other asset like a home or a bank account. But on a business, you can't just name a transfer on death or payable on death beneficiary. It involves a lot more complex planning, like business succession interest documents. And there are some important questions to ask yourself, like who will run the business, who would we sell it to, and things like that. So let's talk about my favorite part of some special consideration estate planning, which is pets. So pets are considered personal property. And a lot of times we regard those pets as family members. We want to make sure that they are protected. You can actually set aside money to provide for the care of those pets after you are gone in what is called a pet trust. If this is something that interests you, feel free to give us a call. We would love to walk you through this very interesting process. That concludes our very basic Estate Planning 101 presentation. If you have any questions or would love to know what next steps are, feel free to give our office a call, email us, come visit us at our office in Wentzville, and we'd be happy to walk you through the whole process. Thank you so much for watching.